Good morning, everyone, and welcome to our presentation on the legal aspects of business. Today, we will be focusing on the law of contract, which is a fundamental part of business law. We'll explore what a contract is, how it is governed by the Indian Contract Act of 1872, and the key elements that make an agreement legally binding. Over the next few slides, I'll guide you through the essentials of this topic, so let's get started. Let's take a closer look at the essential elements of a valid contract. First, we have offer and acceptance, which are the foundation of any agreement. An offer is when one party proposes terms, and acceptance is when the other party agrees to those terms. Both must align clearly for the contract to be valid. Next, there's the intention to create a legal relationship. This means both parties genuinely intend for their agreement to be legally binding, not just a casual or social arrangement. Without this intention, the agreement might not be enforceable. Lawful consideration is also crucial. Consideration refers to what each party is giving or promising in exchange, something of value that supports the contract's validity. It must be lawful and not against public policy. Then we consider the capacity of the parties, or their competency. This ensures that all involved are legally able to enter into the contract, meaning they are of sound mind, of legal age, and not under undue influence or coercion. Free and genuine consent is another key element. Both parties must agree freely, without any misrepresentation, fraud, or duress. Consent obtained through deceit or pressure invalidates the agreement. The contract's object must be lawful. That means the purpose of the contract should be legal and not against the law or public policy. Additionally, the agreement should not be declared void. A void contract is one that is invalid from the start, perhaps due to illegality or lack of essential elements. Certainty and possibility of performance are also important. The terms of the contract should be clear enough to be understood, and the obligations must be realistically achievable. Finally, legal formalities must be observed where required. Some contracts need to be in writing or follow specific procedures to be valid, depending on the jurisdiction or the nature of the agreement. All these elements work together to ensure that a contract is valid, enforceable, and fair for all parties involved. Let's now look at the classification of contracts based on their validity. First, we have voidable contracts. These are agreements that are enforceable by law, but only at the option of one or more of the parties involved. The other party or parties may choose not to enforce it if they wish. Think of it as a contract that can be set aside if the right conditions or reasons arise, as outlined in Section 2(I). Next, we have void agreements. These are agreements that simply are not enforceable by law from the outset. They lack the legal capacity or validity required to be recognized as a binding contract, according to Section 2(G). Moving on to void contracts, these are contracts that initially might have been valid but have lost their enforceability. Once a contract ceases to be enforceable, it effectively becomes void. This concept is also explained in Section 2(G). We also need to consider illegal agreements. These are contracts that violate some fundamental rules of public policy, or are criminal in nature, or are immoral. Such agreements are not just unenforceable, they are against the law and public interest. Finally, there's the category of unenforceable contracts. These are contracts that, due to technical defects, like missing a written form or because the time limit for enforcement has passed, cannot be enforced in a court of law. Despite being valid in substance, they cannot be upheld legally due to these procedural issues. Understanding these classifications helps us see how the law differentiates between various types of agreements, especially when considering which ones can be upheld or challenged in a legal setting. Let's now look at the different classifications of contracts based on how they are formed. First, we have the express contract. This is when the terms are clearly and explicitly agreed upon by the parties at the time of formation. Think of it as a straightforward agreement where everything is spelled out, either verbally or in writing, as per Section 9. Next, there's the implied contract. Unlike the express one, this isn't spoken or written directly. Instead, It's inferred from the actions, conduct, or the usual course of dealing between the parties. For example, if you visit a doctor, there's an implied contract that you'll pay for the services, even if you haven't explicitly agreed to every detail. Then we have the quasi-contract. It's important to note that this isn't a true contract at all. Instead, it's a legal construct created by law to prevent unjust enrichment. Basically, the law steps in to impose an obligation where one party benefits at the expense of another, even without a formal agreement. Finally, with the rise of digital transactions, we now have e-commerce contracts. These are agreements entered into between parties via the internet. They are becoming increasingly common and are crucial for understanding modern contract law, especially in our digital economy. Connecting this to our overall theme, understanding the different types of contracts helps us grasp how agreements are formed and enforced, whether in traditional settings or through modern digital means. Now let's look at how contracts can be classified based on performance. First, we have executed contracts. These are agreements where both parties have already fulfilled their respective obligations. For example, when you buy something and you've already paid, and the seller has handed over the goods, that's an executed contract. Next, there are executory contracts. In these cases, both parties still have obligations to perform. Think of a contract for future services or delivery. The work or payment is yet to be completed. Moving on, we have unilateral or one-sided contracts. These are interesting because only one party is required to perform at the time of formation. For instance, if I promise to pay someone if they find my lost pet, only I am obligated to act once the condition is met. Then there are bilateral contracts. These involve obligations on both sides from the very beginning. Most everyday contracts, like employment agreements or sales contracts, fall into this category because both parties have commitments they need to fulfill. Understanding these classifications helps us see how different agreements function and what to expect from each type, which ties into the broader theme of contract law and how it governs our transactions. Now, let's look at how contracts are classified under English law. First, we have formal contracts. These are agreements that require a specific form or method of creation, often involving written documentation or particular procedures. An example of a formal contract is a contract of record, which is essentially a judgment of court, meaning it's a formal declaration by a court that creates a binding obligation. Next, we have contracts under seal. These are traditional legal agreements that are sealed with a wax or embossed seal, signifying their formal nature. While their use has declined, they still hold importance in certain legal contexts. Moving on, we have simple contracts. These are the most common type of contracts, which can be made verbally or in writing without any special formalities. The key takeaway here is that simple contracts are generally easier to establish and are the foundation of most everyday agreements. Understanding these classifications helps us see how different types of contracts are treated under the law, especially when it comes to issues like enforceability and formal requirements. It ties back to our overall theme of understanding contract law and its various forms.